Welcome to another episode of Judge for Yourself. As you know, these particular programs deal with the Constitution, so we couldn't help but have a look at the Constitutional Court ruling recently in the Renata Barnard case, which has sparked serious debate about affirmative action, race quotas, and restitution within South Africa as a whole. Briefly, Lieutenant Colonel Barnard took the South African Police Service to court claiming unfair discrimination because twice she was refused promotion on the basis that she was a white woman. The Constitutional Court ruled in favour of the police service. In the main judgment, Judge Dikgang Moseneke, the Deputy Chief Justice, said the courts had found that the SAPS Employment Equity Plan is a restitutionary measure conceived by the Constitution and the Employment Equity Plan. All of the judges found in favour of SAPS on one basis or another. All were concerned with the appropriate test which had to be applied to affirmative action, if we wish to use that word. But all were unanimous that restitution, because of historical disadvantage, because of the racism of 300 years, was enshrined in the Constitution to reconstitute a constitutional society. And all recognized that on one level there was a tension, if you wish, between the equality provision and the restitutionary measures. These really are profound questions, and it is important that we discuss them. And if you'd like to participate in the discussion on Twitter, please use the hashtag #JFYAffirmative. To discuss this topic, I'm joined by Advocate Vuyani, Ngalwana, a senior member of the Johannesburg Bar, Advocate Dirk Groenewald from Labour Group Solidarity, and Marius Redelinghuys, MP and spokesperson for the DA. So what is your approach to this particular issue in the light of the judgment?
Well, clearly we as Solidarity, we were disappointed with the judgment in light of 5 judges from the SCA which ruled in our favour.
Yeah, but you lost 11-5. That's a big defeat in soccer terms.
We lost 11-5. I think the Constitutional Court clarified some issues on the Employment Equity Act. I think they clarified the issues of quotas, absolute barriers, the fact that in terms of affirmative action you cannot appoint mediocre or incompetent people, the fact that you have to have an approved employment equity plan in place. So all of those are positive issues of the Constitutional Court. The issue that we have is that we feel that the court didn't deal appropriately with the facts that was enunciated within the trial.
All right, before I ask my other panelists, can you just very briefly tell me what it is that you object to?
Well, the fact is, firstly, if you have a look at the reasoning of the court to say why there wasn't an absolute barrier with regards to Lieutenant Colonel Barnard, is due to the fact that later on she was appointed. Now, those facts weren't before the Labour Court. Those facts, you know, the whole argument of you are bound by, at the point of litis contestation, when the facts are before the court, that is that. You know, the courts can't have a look at facts thereafter. Now, one of the main reasons the court found that there weren't absolute barriers because Barnard was appointed thereafter. A further fact was the argument that in terms of the court's view, there was a number, white women were overrepresented on those levels, but there was no argument presented in court as to why that was. There might have been a justifiable reason, but there was no evidence on that point.
All right. What does the DA have to say?
Well, this is a very interesting judgment for us, and one that
You guys aren't very keen on this stuff, are you, affirmative action?
Well, we are. We actually do support affirmative action.
Well, tell me what kind... sorry, all right, I interrupted you.
This judgment outlines exactly our position on it. It outlines the need for measures that redress the structural and entrenched socioeconomic legacy of apartheid, but it also at the same time clarifies how that should be done, in that it cannot be punitive, it cannot be retaliatory, and it should always be dependent on rational criteria applied through a plan and without the use of quotas, which is the DA position.
And how did you react to this result?
It was an interesting case that we watched from its inception, because it is a case that challenges a number of assumptions and a number of manners in which affirmative action is applied across the board. It's a case that South Africans were watching, and because it is such an emotional issue, it was very important for us to follow the case to the Constitutional Court, where there was...
I appreciate you followed it. I'm really much more pressing you for your reaction. Did you think did you embrace it, or did you think, oh my goodness, this is not what we would do if we were in power?
As with every Constitutional Court judgment, it was studied, and we have to concur with the Constitutional Court, and that we welcome the fact that it has outlined a number of those critical issues.
Right, okay. Mr. Ngalwana?
Yes. Well, let me take issue first with what Dirk said. He said, and I'm not here to debate, I mean to disagree.
No, you're
with
happy
you.
to debate. That's what we're here for. That's what we're here for.
He says the facts were not before the Constitutional Court as regards the overrepresentation of white women. In fact, they were, because it has been a legacy of apartheid. Those facts were before the Constitutional Court. That's the one thing. The second thing, he says the court took into account facts that happened after the pleadings had closed in the Constitutional Court or in the lower courts. That's not entirely correct, because it was on the papers the fact that, in fact, I think it's in paragraph 46 of the Barnard Constitutional Court judgment, where Musanege, acting Chief Justice, said there can not possibly have been an absolute barrier to the advancement of white women because Ms. Barnard, or Captain Barnard as she then was, had been promoted all along this time. And so that is absolute proof that this thing of absolute barriers is a smokescreen.
But there is a debate within the Constitutional Court. Admittedly, the majority went one way and the others the other way, about what the appropriate test should be. And
Yes.
there is also no doubt that this particular case turned a lot on the facts.
Absolutely.
Because Colonel Barnard, to her great credit, never attacked the equity plan.
Yes.
She said the equity plan is fine. I think the equity plan has been implemented unfairly.
Yes.
So, in fairness, are we still a bit in the dark as to precisely what the law is on this issue?
No, I think the Constitutional Court made it absolutely clear. In fact, I noted about 6 points that one could take out of the Constitutional Court judgment. The first was that there are no quotas here, and the Constitutional Court did define what quotas are. They defined it as something akin to job reservation.
They said it wasn't necessary, however, to call for definitive finding on quotas.
Well, initially, that's what Musanege said, but subsequently, he said one could define it as job reservation. Secondly, the Constitutional Court said, look, white people, and this is van der Westhuizen and J, white people benefited from apartheid. Well, he didn't call it apartheid, he called it something else, but which is code for apartheid. And so even if people say, I had nothing to do with apartheid, therefore why should apartheid apply to me? Van der Westhuizen and J says, quoting a speech of Kennedy, I think, in the United States, said, well, we have to bear the brunt of it. In fact, that wasn't the first time, Dennis, sorry if I can say this. It wasn't the first time that the Constitutional Court said this. In 3 previous decisions, you'll recall in Belporto in 2002, Van Heerden in 2004, and I think Battlestar Fishing in 2004 as well, said it is inevitable that those people who had benefited from apartheid would increasingly be adversely affected by transformation measures, and this is inevitable.
I want to allow you to take issue, but I have to take a break first, and I'll give all 3 of you an opportunity.